Now turn to the second case on this morning's docket. This is case number 102981, State of Kansas v. Calvin Charles.
May it please the Court, Meryl Carver-Ullman, Capital Appellate Defender on behalf of Mr. Charles. And if I could please have 4 minutes for rebuttal.
4 minutes is granted.
Thank you. I didn't actually intend to spend any time talking about this, but since everyone's talking about restitution and I had the benefit of being able to sit in the audience, it's easier to think down there than it is up here. In answer to your question, Justice Lukert, I think that Rule 2.03 does not save this as far as a premature notice of appeal because of the language in the rule that says a notice of appeal that complies with KSA 60-2103B filed after a judge of the district court announces judgment to be entered, but before the actual entry of judgment is effective as a notice of appeal. And there's more, but here that isn't the case because the judgment wasn't announced until much later. As you were saying that, hundreds of hours of doing jurisdiction checks started ringing bells in my head, and I was like, wait, that's not right somehow. So I think that as much as it seems like it would be a nice fix to this conundrum that seems to have been created, I don't think that that is actually a viable fix under Rule 2.03. But moving on to the substantive issues in the case, Ms. Cessna actually covered a lot of probably what I would have said about the burglary. The only thing I would add is, Justice Breyer, you were talking about entering into and remaining within being mutually exclusive, or not being mutually exclusive, because there's overlap.
Legally distinct, but factually overlapping.
Exactly. And I would argue that this is a case where it's not actually overlap as much as it is one totally subsumes the other. If the legislature wanted the statute to say that, I would suggest that they could have said being in a dwelling without authority is the crime here. But they divided it out into two separate things. Therefore, I think that the legislative intent is that they be mutually exclusive.
It's a different Venn diagram than I was suggesting.
Exactly.
It doesn't matter. That's the question. Okay. When is the cigar?
I'm sorry.
Never mind.
Okay. Since Ms. Cessna covered the burglary pretty thoroughly, if there are any more questions, I'd be happy to answer them. But if not, I think I'm going to go on to the theft. I think, and this, I missed it in writing the petition for review, but going back and reading the Court of Appeals opinion this past week, there's something in there that's actually really troubling to me, and no matter what the outcome of the eventual issue is, I think it's something that probably needs to be corrected. The Court of Appeals cites to State v. Carpenter, which is a 1980 case, and it's cited in page 9 and 10 of the Court of Appeals opinion, and basically the Court of Appeals suggests that it says, and I think reading Carpenter, it's right, that there is some sort of harmlessness prong to sufficiency analysis. Because basically, in Carpenter, and Carpenter was a homicide case where apparently the state could have charged premeditated first-degree murder, but charged second-degree murder instead. And then the defendant came back and argued, well, my conviction for second-degree murder isn't valid because there's obviously premeditation here. I should have been convicted of first. And the court said, the state doesn't have to charge the highest crime that they possibly can, which I agree with. And B, even if he got convicted of the wrong crime here, he got less than he was supposed to get anyway, so no harm, no foul. And I've never seen any sort of prejudice requirement like that, and I checked with a couple other attorneys who were awake at midnight last night about that, and that's something, and even in Carpenter, they're citing some 1920s cases, so to the extent that that's language in this case, that's very troubling to me, and like I said, no matter what the outcome of the eventual issue is, that seems like something that needs to perhaps be corrected. As far as the rest of the issue, I mean, our position is pretty clear. What's good for the goose is what's good for the gander. If we can't get a lesser included instruction on something, I don't understand how a conviction on that can meet the sufficiency standard. Those are kind of two sides of the same coin, and it just doesn't make sense that in a case where if we had requested a lesser included instruction, we couldn't have gotten it. My client can then be convicted of that crime that we couldn't have requested a lesser of even.
Why couldn't they? Why couldn't the defense counsel argue that the jury could decide that the handbag wasn't worth whatever?
I mean,
Why couldn't they get a lesser included instruction?
Defense counsel absolutely could argue that, but I think cases Nesmith and Bryant cited in the brief, in both of those cases, a lesser included instruction was not given at defense counsel's request, and the appellate courts found that that was okay. I guess that's the problem, is that I think absolutely defense counsel could and maybe should have argued for a lesser, but I think given past appellate court decisions, that request would have been unsuccessful.
Well, there was no reason to ask for a lesser here because it was prosecuted as a lesser.
Exactly.
Your argument is that...
The flip side, yeah.
Yeah, and you didn't cite to Jenkins where this court said that looking at the theft statute, a third misdemeanor theft offense is a felony. And so if that's the case, why isn't theft of property of at least $1,000 is a felony? You use the same rationale.
Okay, say that again, I'm sorry.
In Jenkins, we said that a felony is a felony if the statute says it. And in that case, we said a third misdemeanor is a felony, citing to the statute. Here it says theft of property of at least $1,000 is a felony. And so I'm wondering why you aren't arguing that this is a felony by statutory definition, so it couldn't be prosecuted as a misdemeanor.
I guess I thought that that's what I was arguing.
The Nesmith case you mentioned was currency, so that didn't really work for you. Do you know what was stolen in the Bryant case?
The Bryant case was actually property, and if I'm remembering correctly, and that was one I wanted to mention because it was another case where, because in the Court of Appeals here, they said that it was a close valuation, basically, and the Nesmith, or the Bryant case, I'm sorry, it was like a coat and some articles like that were subject to sort of interpretation as to valuation.
Right.
And in that case, the felony limit at that time was $500, and the evidence established the property was worth $645. So that's actually less of a difference than here. That would be a $145 difference over the limit, as opposed to here where it was $280 over the limit and $480 over the limit, respectively. So I think that case is, if they couldn't have gotten a lesser in that case, then it doesn't make sense to me that my client could have gotten convicted on that theory in this case. If there are no other questions.
Yeah, I do have a question. We have, with respect to the valuation, we have the rationale that the jury could have found beyond a reasonable doubt that the value of the property was not at least $1,000. But then we have a district court making a finding that restitution in one case is $1,282. How does that comport that you have a jury finding that it's not $1,000 and a court finding that it is over $1,000?
It doesn't.
Well, is there a difference in burden of proof, perhaps? The jury has to find beyond a reasonable doubt, the restitution is preponderance, or how would you didn't make that argument, but...
Well, and I think restitution, there has to be, if I'm remembering correctly, and I'm just pulling this off the cuff, but I think there has to be substantial competent evidence to support the restitution figure, whereas the jury finding is beyond a reasonable doubt, obviously. And, perhaps that's an argument I should have made as to, the jury had already found beyond a reasonable doubt that it was less than $1,000, so there obviously wasn't substantial competent evidence to support it being over $1,000, for the figures that were actually awarded. I think that's probably absolutely an argument I should have made.
Well, making a victim whole and determining value are two different things, aren't they? It's part of the equation, part of the calculus, but it's not the only calculus that's used in determining restitution.
And that's absolutely true.
Did you,
I do have one more question.
I was just going to ask if you had anything further to say about the restitution issue.
And not that already hasn't been covered, I don't think.
Very good.
I have one more question about that, but it again goes back to that jurisdiction, kind of appellate jurisdiction area. The notice of appeal in this case, how was it worded?
It says, appealing the district court's decision concerning all aspects of the jury trial, the verdict, and all issues concerning sentencing. So it's fairly inclusive.
Okay, thank you.
Any further presentation? Any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court, Chris Elslager appearing on behalf of the state. And just because it's at the top of my head, I want to address that last bit about restitution, is that the restitution doesn't necessarily include only the amount of the items that were stolen. I think some of the victims said they had to change their locks and so on and so forth. So there may be other costs that are included in the restitution and that are not necessarily the value of the items stolen. But now jumping to the front.
But I can't remember her name, where I think from the stand said $1,282 is what was stolen, and that was the amount of restitution. And so it's a little difficult to say, well, the court may have included other things, isn't it?
Well, I just know that there was testimony that at least some of the witnesses said that they had to change locks and so on. So it's not, restitution encompasses more than just the loss. So
I understand the concept. I was just applying it to this particular case, is we have the argument that all the evidence established a value of over $1,000. The only way we can support the misdemeanor is to say, well, the jury may not have believed that evidence, but then we turn around and the judge believed it and used it to impose restitution.
Well, I'd have to go back and look at the restitution. I don't know what the judge, if he laid out what he based his findings on, and I guess moving backwards then towards the with the theft. The fact that we possibly may have overproved the crime, I don't think undermines the sufficiency of the evidence proving the lesser crime. I mean, clearly, if somebody stole more than $1,000 worth of stuff, they also stole less than $1,000 worth of stuff. It's subsumed within it.
Well, that gets back to what I was asking about Jenkins. Jenkins seemed to say that the definition is jurisdictional. So you're saying that you have jurisdiction to convict of a crime that doesn't meet the elements, or where the proof doesn't meet the elements of the lesser. You follow what I'm saying?
Yeah, but here's the thing. I don't think in this case this is the right case to even kind of address that, because we don't have a stack of money that we know this was $1,200. We don't have a single large item like a TV that was $2,000. You have a whole bunch of little items, and the jury is free to value those, and the prosecution looking at going forward.
Are they? Is a jury free to place any value it wants to on something? I disagree with that. I think the state has to prove beyond a reasonable doubt. The jury can refuse to believe the state's evidence.
Maybe that's what I was saying. I mean, the jury is free to assess the credibility of the witnesses and the weight to give their testimony, and I think that they could. I think it's within their prerogative and their common sense to disagree with somebody if they say this handbag's worth $1,000, but the jury just says, I don't believe that. I think it's worth less.
And the way you get there then is our case law that says that if there's no evidence, the misdemeanor
It's worth something.
it's worth something. The misdemeanor conviction can be upheld, but I don't think you can say the jury is free to figure out what it wants to put as value without
Well, it has to
any
be based on some
evidence.
evidence.
Yeah.
Right, I guess I misspoke. It has to be based on some evidence, but it's the
Right.
jury gets to weigh that evidence. And in
that's
this case,
I think that's the point where I'm getting hung up on this case. I keep coming back to a recent decision of this court in Weir. I don't know if you're familiar with it, but the court split in that case. There was a charge of reckless aggravated battery, and the defense was that they proved intentional aggravated battery, and the majority agreed and found the evidence insufficient. And I dissented and bought basically the argument you're making today, that by it within the evidence there was also evidence of recklessness. But I'm not sure you can convince me to stay in that position in this case for two reasons. The statutory language is very different. The definitive statement of less and more seem to make a difference. And then I'm troubled by, is there any evidence of a lesser value?
No, I don't.
And so how do you answer both of those things to help me get
I
over?
mean, the evidence was of the value were approximations given by the victims, and so they're just
I
approximations.
understand that, but is there evidence to support a jury verdict of a lesser value, of a misdemeanor value?
Well, I think it's the description of the items themselves and so on. I mean, it's the jury does not have to check their brain at the door. I mean, they come armed with their common sense and knowledge, and they can assess if somebody, if I hold up a cheap handbag and I tell the jury this is a $1,000 handbag, the jury, I think, is capable of looking at that and saying, no, this guy's not, he's not credible, that's not a $1,000 handbag. But as he said, it's worth something. So I think there is wiggle room in there for the jury to determine whether it's more or less than something. It's not a precision finding. And again, I think, if it doesn't render the evidence insufficient if we overprove the crime. And that's what Carpenter said. It wasn't really a harmless error analysis so much as saying, look, if the state's overproved the crime, that doesn't harm that doesn't render the evidence insufficient. It just gives you even more evidence. I mean,
That's what my dissent in Weir said as well. You've convinced me of that point. I just am troubled whether I can put that into this case given the statutory language about more and less.
well, I think it's the same situation where if the state has put on an evidence that overproves the crime, I mean, certainly less than $1,000 is included, is a subset of more than $1,000. We've included that he at least stole that much, and the jury is, I think, within its bounds to find beyond a reasonable doubt that he stole at least, less than $1,000, at least $999 worth of stuff, especially given the fact that you've got a whole lot of different items, and the valuations were approximations, not precise testimony. And again, even if we overproved it, that doesn't mean the evidence was insufficient. It was sufficient to prove that he stole these items. And then I guess finally on the alternative means question, actually I think Justice Breyer is right. I think no matter how you look at this, whether alternative means or otherwise, this is a no harm situation. The evidence proved that he entered, and the evidence was sufficient to prove that he remained in these houses to steal things. So regardless of how you look at it, the evidence was sufficient.
With respect to the restitution, I understand the numbers came out of the PSI, the pre-sentence, and I'm assuming the CSO, in preparing the PSI, got those numbers from the victims. So can we say that the victims did not request, that these were not victim requests for restitution? And the reason that's important is that 2234-24D says that the victims request restitution, there shall be a hearing before sentencing. You follow what I'm saying?
I'm not following it, actually.
Well, the statute says if the victim's request, at the victim's or victim's family request, for restitution. The court shall have a hearing before sentencing.
Okay.
And we've gotten around that in some cases by saying, well, the victims didn't request it in this case. But I don't know if you get the numbers from the PSI, how you can, with a straight face, say that the victims didn't request the restitution.
Yeah, I don't know in this case how
How that came about.
I just don't know. I just can't give you an intelligent answer.
I do have a question regarding just the process of why we have so many continuations to determine restitution when it's pretty obvious from the outset of the case, even from charging, that there's going to be some restitution. So there's plenty of notice, and I understand in the last case with Ms. Isherwood that perhaps medical bills come in late and there's problems with that. But in the typical case like this, where there's just valuation of property, you make this claim, what's the problem with just having that be a part of the sentencing and typically be a part of the sentencing? And I was trying to recall, I remember continuing for a determination later was a fairly common practice when I was doing these things. But in hindsight, I'm wondering what's taken so long and what's the problem with just requiring its sentencing if you're going to have restitution to be done there? Except for these exceptional circumstances where perhaps there's delay with insurance and medical bills and figuring that out. That I understand that, but the rest I really don't understand.
And neither do I. I mean, I can understand, if you have medical bills and stuff that have to be determined, sure.
Why can't you just continue sentencing in that case?
Altogether.
I guess you could. I mean, why in this case there was just one?
No,
The real world is that the CSOs are overworked, they get the PSI out just before sentencing, the prosecutors are overworked, they get handed the
I understand all
PSI.
that. That's right.
They don't have all their act together to present proof if defense says prove it, and so
I understand
that's how it comes down the pike in reality, but that doesn't mean that we can't follow the statutes by simply saying, well, we're not prepared today, we need to continue.
Well, I appreciate that explanation.
Sentencing has to happen
Right.
within a certain number of days, which there isn't.
The other reality is there's pressure to get them out of the county jail and into the state system as
Housing
quickly
issues.
as possible.
And of course, I'm insulated from all of that, so I'm probably not the best person to ask why. I mean, because I honestly, Justice Bozen, I look at it and I go, again, I scratch my head and wonder the same thing.
Yeah.
If there are no further questions, that would conclude my argument. Thank you.
Any further questions of counsel before he sits down? Thank you, counsel.
May it please the court. I don't know that this clarifies anything at all, but just looking through, and I don't have page numbers, but it's in volume 3, and it's a fairly small volume. There is a victim request for restitution, and there are 2 pages of it, and one is a victim statement, and one is, again, not the right person to ask about district court procedures, but the victim statement, at least, is dated a day before sentencing, so I don't know if this is something they could have had before sentencing, if it just got lost in the mail. Again, probably not clearing up anything, but just that's what the record shows. Secondly, I wanted to make the point that this is not really as to the theft issue. This isn't a case where, like with Carpenter, with the murder case, where the state overproved its case. This is a case where it's an entirely different element. The value of it is an element of theft, and it's not overproving. It's a completely different number. I'm not saying that very well.
It gets a little fuzzy. I understand your argument, but it gets a little fuzzy when our cases have said we presume property has some value, so you don't have to prove a value of less than $1,000. We've got cases that say that, which makes it a little fuzzy about separate elements that must be proved, and that's really only the case for the felonies, because we haven't really required value proof for misdemeanors. In fact, if you don't prove the felony, we just send it back and say re-sentence as a misdemeanor.
Yeah, and I understand that, and I guess I would just go back to, and I don't want to beat on a dead horse here, but and I really don't even care which way it is, but either we should be able to get the lesser, or there shouldn't be sufficient evidence of this. Like, one way or the other, I don't care, but we can't lose both times. I guess that's the crux of my argument. But that concludes what I have to say.
Any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.